I'll bring them up.
Oh, yeah.
Thank you so much. May I approach? Thank you. This is a smile.
I don't need, I already have my list. You can take that. Yeah, I already have my list. I got that already.
20.
Pardon me?
We have all 20 on yours?
Yeah, no, 19.
Yep, so here's one with the last person. Yeah, there's one.
I believe our office would have sent out the appearance. I want to make sure you have the file. If not,
Well, I'll check.
hand
Let's
direct
see.
one right now. 33788.
And then. Let's see. Hold on. Let's see.
Good afternoon, Your Honor.
Afternoon. Let's see what this one is. All right, so. Good. Awesome. Kid. Johnson, zoom in. Fox. All right. This down. Wording. Shut this down. All right, folks, here we go. We're going to be doing James Fox. Mr. Fox, please say your full name.
Fox and third.
Okay. Fox was third. Okay. All right, I'm Magistrate Trudfaya. Case number 2404537801. You have an attorney. Go ahead, counsel.
Today, Your Honor, Robert Kirping, on behalf of President my client, Mr. Fox. Under today's date, I'm trying to set the ready to say on reading of the plan. Mr. Kirping is not guilty and asked the court to entertain bond.
Okay. Yep. And counsel, there is no appearance.
So, Judge, I apologize. I know that we sent something out. Do you want me to do one for you?
Yes, please do.
You have a form I can take outside?
Okay.
Or if you're.
Ladies,
right
do we
now.
have any attorney forms? Appearance? Okay, good. I'm gonna enter plea of not guilty. Court date is December 11th, 2024. Pre-trial for Judge Garrett, Austin Garrett. Mr. Fox, bond conditions. One, you're not to have contact with Cal bonds. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Two, let me see. You're not to possess any firearms or any other dangerous weapons. Okay. Counselor Ragnan, give me a recommendation, please.
Good afternoon, Your Honor. Samuel A. Ragnan, P23-157 on behalf of the people. Your Honor, the defendant is currently on probation for carrying a concealed weapon. It's 12-month probation out of district court that he is on. Your Honor, we're going to ask for a $25,000 personal bond, tether home arrest. He's on probation for one case, and now he's got another case. And this is very assaultive. We think that tether, perhaps with the work release, would be approved. Thank you.
Go
With
ahead.
the court's permission, if I can.
Go ahead, sir. Go ahead, counsel.
Thank you, Judge. We would beg to differ, Judge. My client takes this matter seriously.
So you're saying that you object to the personal bond?
Well, to the tether. And
Okay.
arrest.
So you're not objecting to the personal bond?
No, Judge.
Okay, so $25,000 personal bond. Nobody has to pay any money for you to get out of jail, Mr. Fox. Go ahead, counsel, rest.
Yes, Judge, but I heard from our probation officer or our interviewer talking about a tether of some sort or house arrest. To that end, we disagree, Judge. My client takes this matter seriously. He's retained counsel. We are here today walking in freely on the date and time set for the arraignment. There was not a warrant that was issued against him. He walked himself in freely. We adamantly deny these allegations, Judge. We have videos that seriously contradict the allegations asserted by the complaining witness, and that day will come when we get in front of our judge for the trier of fact. But Judge, there are compelling videos that show something contrary to the allegations asserted against him. This is a man who has worked very hard at maintaining his relationship with his kids. He hasn't had the pleasure of seeing his kids. We believe that house arrest when he has a full-time job is contradictory. He should be able to go ahead, go where he needs to go. He shouldn't be restricted. I understand the concerns that the probation officer has brought to this court's attention regarding a violation of a concealed weapon. But Judge, with due respect, here we are today walking in freely on the allegations. So the fact that he is taking this seriously, the fact that he holds down a full-time job, the fact that he is here today without anyone chasing him down and arresting him speaks volumes, and I would ask the court to deviate from part of the recommendation. Thank you.
Okay. Counsel Ragland?
Yes.
Okay. What's the reason for the GPS tether?
Just to protect the complaining witness, Your Honor, and as mentioned.
Okay, so
that's the only
let me
reason.
ask you this. So Counsel Ragland, this allegedly happened back in October 25th, which would be about over a month ago. So tell me, has there been anything new happening?
I have no information. It's not a
Okay.
problem, Your Honor. Whatever, obviously, I'm certainly concerned only for the welfare of the complainant, but that's fine. And
Thank you. Yes,
Please continue, sir. I apologize.
was there anything else, Counsel Ragland?
nothing further. Thank you.
Thank you. All right, courts heard the representations of both sides. Charges of domestic violence about a month ago in this particular matter. From what I see is the complainant did not seek medical attention, allegedly that she reported soreness in her right hip in this particular matter. Okay, and Mr. Fox did come in. Whether or not he came in with an attorney, this court, that doesn't tell me anything, because a lot of people come in with attorneys. That doesn't mean that they're going to continue, but that he came in this particular matter, this court does take that. There is no flight risk. There is a little bit of danger in this particular matter, but I don't have anything to indicate that he has prior domestic violence or assaultive behavior in the past. Is that correct, Counsel Ragland?
That's my understanding. Yes, Your Honor.
So in this particular matter, $25,000 personal bond. Nobody has to pay any money, Mr. Fox, for you to get out of jail. So all you have to do right now is just take a seat, wait for your paperwork, okay?
So Judge, two requests. First of all, what's the case number? So I put this on the note on the appearance.
Pardon me?
The case number again?
240-453-7801.
I'm sorry. I've got 25,000
40.
personal bond. Yes.
$25,000 personal.
Thank you.
240-453-7801. Okay,
Thank you, Judge. Is it a city or a state case?
this is a state.
Thank you. Your Honor, I do
Thank
want to
you.
point out one of the things for the record. One, mom has filed a PPO that still exists.
I'm sorry.
Two things I want the court to have knowledge of, given the assurances. One, mom has filed a PPO against my client, and apparently it's valid. So it sits there right now. So he has restrictions. And two, since the filing of her PPO, she's been reaching out to him. Judge.
So
And
I can't, the court is, we don't have control over the others, but we have control over him. So that if he violates, because
Yes.
if the complainant is calling him and he's picking up, that's a violation.
Yes.
So there should be no reason for you to have contact with the complainant. Do you understand that, sir?
Right. Yeah.
Okay,
And what is our return date, Judge?
December 12th, December 11th. I repeat that, December 11th, pretrial in front of Judge Austin Garrett.
In person or resident, Judge?
I believe it's gonna be by Zoom.
Your Honor, you have been wonderful, you and your staff. Thank you so very much. Happy Thanksgiving.
Thank you. Happy Thanksgiving to you.
Thank you, Counselor.
Thank you, sir.
I am a prosecutor, by the way. Not a
Yeah.
probation officer. That's
I
okay.
apologize. Well, you made the recommendation, so.
That's
I
fine.
misunderstood. Please,
Not
happy
a
Thanksgiving.
problem.
Take care.
Same to you.
Thank
Thank
you.
Kidding. Thank you.
We're good. Thanks, sir.
Thank you. Joshua Kidd, please step forward. 3 matters. Yep, okay. Mr. Kidd, thank you for coming in. There's 3 cases. First case is 240-4464-801. That is retail fraud. The other case is 240-4465-201. That is assault and battery. And the other case is 240-6021-501. That is resisting obstructing police officer. Sir, please give me your full name.
Officer Jermaine Marcus Kidd Sr.
Thank you. You have an attorney. Go ahead, Counsel Shad.
Good afternoon, Your Honor. Justice Radke, number 81798, on behalf of Mr. Kidd, who is present in the courtroom, waiting for more reading, understands his constitutional rights, and stands to you.
I'm going to enter a plea of not guilty, misdemeanor matters. Court dates are December 11, 2024, pre-trial in front of, and make sure, in front of Judge Jones. On the assault and battery case, you're not to have any contact with a Fadi Sulak. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to go back to the Greenfield location. You're not to possess any firearms or any other dangerous weapons. And those. Under the other misdemeanor matter, excuse me. Sorry. Let's make sure that we're on the same page. We have the same paperwork for the cases. Yep. The other one was retail fraud, the other one assault and battery. Let's make sure. Retail fraud. Retail fraud. Same thing. Same 3 bond conditions, no firearms of any kind, no contact with Fadi Zulak, and you're not to go to the Greenfield location. These are on the misdemeanor matters. Felonies. I'm going to enter a plea of not guilty. Court dates are December 6, 2024, probable cause conference, followed by preliminary examination. December 12, 2024, both matters in front of Judge Jefferson. Mr. Kidd. Let's see what this is. Yeah. No assault for combative behavior. This case is pending. You understand all the bond conditions, sir?
Yes.
Okay. Who's Counsel Ragnan? Give me a recommendation.
Well, Your Honor, first of all, I just want to say this is a situation where he has these 2 cases back from April 30th, and the one that's very assaultive to the clerk of a gas station, a liquor store, I believe it was, and he was designated at that. He was told his bond condition when he was arraigned. He had a $10,000 cash bond that was subsequently reduced to $10,000 personal. But he was told then no contact with the complaining witness. All right. And then we have on 10/28/24, he ends up back in the store, pushing his way inside the store, and then goes through several bouts of resisting and obstructing arrest. So I'm just concerned about the welfare, first of all, of that complainant. And number 1, why is he back at that store when he's not supposed to be? However, I understand that that I would just be asking for a personal bond, $50,000, Your Honor. 25 well, give me 25,000 on each one, and I'd ask for a tether on the police assault case with work curfew. That's
Okay,
agreeable.
on misdemeanor, which is the case number 2404464801, which is the charge of retail fraud third degree. There is a $2,000 cash surety. That was by Judge Jones, November 25th, 2024. All right. The other misdemeanor, assault and battery, bond is $2,000 cash surety. Judge Jones. And this looks like, and the assault to resist obstructing, that is not a CAPES. Is that correct, Council Ragland?
That's correct.
Okay,
So, Your Honor, let me just clarify this again, bring it up to you, okay? $25,000 personal bond on the two cases, okay, on each of those cases. And on the felony police assaulting, I would just ask for a $50,000 personal bond. He's come here 2 days in a row. He has shown up when he was supposed to do so. So I guess we just ask for no tether, but just $50,000 personal bond.
okay. So the misdemeanor is $20,000 and for the felony, $50,000 personal bond.
Correct.
Okay. And Council Shive, you're not objecting?
We're not objecting to any of that, and just so the court is aware, I know this court has authority to change the bond, but Judge Jones did say personal bond on those matters, through Attorney Philip Reagan yesterday. We have it, because Mr. Kidd was here yesterday, so we saved that information for today, so we wouldn't be objecting to any of that. Mr. Kidd understands he needs to make to all his court dates, and as Mr. Ragland said, Mr. Kidd came here 2 days in a row, and he's here, although he even had transportation issues, he called ahead of time and figured it out and got here, before 2:30 and was not late, so he will come to all of his court dates, Your Honor, and he understands what the court, said. And he apologizes for anything that may have came off as rude yesterday, and he is here to show the court that he's going to take care of all his matters, so we will not be objecting to any of that.
Thank you. Mr. Kidd, did you want to say something? Pardon me?
He has nothing to say at this point.
Council, you said he wanted to say something,
No,
so he can say something.
he doesn't, he said he doesn't want to say anything.
Okay, so. All right. Mr. Kidd, on the misdemeanor matters, you're gonna get $20,000 personal bond. Nobody has to pay any money for you to get out of jail if you were in jail. But understand those bond conditions, sir. Any violations? Okay, next time it may be a monetary bond. Felony matter, $50,000 personal bond. No KPS, no GPS tether on any of them. Council Reagan, did you want to say anything?
No, I just want to stay away from that store, liquor store.
Okay,
So, that's it.
well, Mr. Kidd knows you only get so many chances before it comes back if you're not obeying. So. Okay. Mr. Kidd, thank you for coming. Do me a favor, take a seat, wait for your paperwork, okay? Thank you.
Thank you, Your Honor.
Thank you. All right. Let's see. Okay. Council, let's see what we have. Council Woodside.
Good afternoon again, Your Honor.
What do you have again?
Just checking back in on Mr. Cameron
Edwards?
Edwards, yeah,
Okay, he's on the list. Council, what's your P number?
41295. I am appointed to Mr. Edwards.
Okay.
Did the court receive the notice from Judge Sabri's courtroom? It reinstated his $25,000 personal
No, I
bond.
haven't received anything. So
I can-
let's see.
I can forward the email to you.
Okay, ma'am. Let's see, we have somebody else. Let's see. Who is this person?
I'll forward it to you right now.
Thank you, ma'am.
What email shall I forward it to, Your Honor?
The court's email.
Courtroom 134?
Now, do, Laura, Laura dot Echartea, ECHARTEA,
EC, wait a minute, HCE.
H.
That might have popped up at 36. Got it. Got it. Thank you.
So the warrant was issued back in 2004.
Hey, Jeff Perlman, how can I help you? Jeff Perlman.
July 21st, 2004.
Yes, that's correct. Good afternoon. I'm here for Attorney Jeff Perlman. We're trying to see if our client is being arraigned today, a Ms. Jan Goodschmidt.
Been reassigned
Say that again?
to different.
I'm sorry?
What's her name?
Goodschmidt, Gutschmidt.
No, ma'am.
Okay,
Where's
Thank
Ms.
you.
On the list.
All
Sure,
right.
have a good day.
you too.
All right.
I tried to.
All right, we got that. EDC. Awesome. Good afternoon, DDC. Good afternoon, DDC. You need me to call you again? Hey, can you hear me clearly?
Yes, ma'am.
Okay, do you have a copy of the list?
Yes, ma'am.
We can go, give me, no, we can go straight down the list.
Okay.
DDC, I'm sorry.
Yes, ma'am.
Could you bring Mr. Edwards, number 18? He has retained counsel.
Okay. Camera here.
Sir, please, state your full name.
Cameron Lavelle Edwards.
Mr. Edwards, I'm Magistrate Echapia. Your case number is 240597831. You have an attorney. Go ahead, counsel. Woodside.
Very good afternoon, Your Honor. May it please the Honorable Court, Sharon Clark Woodside, appearing on behalf of Mr. Cameron Edwards. My bar number is 41295. Your Honor, I did indicate to the court earlier, Mr. Edwards had been capious from this past Monday from Judge Elias Bree's courtroom on a matter. As it turned out, he had been in custody in the Oakland County Jail, was released and transferred to the DDC last night, all of which was verified and informed Judge Sabree.
Counsel,
Reinstated his bond.
counsel,
Yeah.
counsel, do you waive formal reading, stand mute?
Yes.
Thank you. I'm gonna enter plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Sabri. And let's see what we have in terms of bond. All
He was reinstating his.
right, Mr. Edwards, bond conditions. You are not to have any contact with Natalie Jackson. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. And let's see, anything else. You both reside at the same location. You're not to go back to the John R. residence. Do you understand that, sir?
Yes, ma'am.
Hold on for a moment. Let me put that on your paperwork, sir. Council Woodside,
Yes, ma'am.
is this a home or is this like an apartment?
I don't even have the discovery for this case. I've been trying to track that down. I have spoken with his father, and that's where he'll be residing.
Okay, well, he's not to go back to the John R. residence.
Okay.
Okay, okay, with that, okay, and I did see, Council Ragnan, there is a KPS, but I also received an email. Let's see, and let me tell you what it says specifically. Email is from Judge Sabri, who indicated $25,000 personal bond with a tether.
We honor the people would not be appearing on this matter, but thank you.
Thank you. All right, so this particular matter, this is going to be a tether.
Oh. Can I say something?
Sir, you have an attorney to say whatever it is on your behalf. You do have the right to speak. Council Woodside?
Judge, I didn't think he required a tether in the email.
No.
Did it say tether? Wait a minute, let me, the email I just sent to you.
Okay, okay. Says right here, today approximately at 12:04 p.m. in terms of bond, $25,000 personal with tether.
Okay, I forgot, sorry.
Can I say something?
What is it that you need to say? So I prefer you didn't, because everything you say can be used against you. It's all recorded.
Yes, what I was just stated last time when I was released with a personal bond with no GPS tether.
That was she.
That's
Well,
what was released from Wayne County.
Sure. In this particular matter, Judge Sabri indicated a tether, sir.
That's what's on the document.
So it's with a tether, $25,000 personal bond with a GPS tether. Thank you. That concludes Mr. Edwards.
Thank you.
Here you go. What's your name, sir?
Rashad McCullough.
Rashad Deshaun McCullough.
Yes, ma'am.
Sir, Magistrate Chartea. Your case number is 2404603-101, sir. You have an attorney.
Good afternoon, Your Honor. Ianfa Roberts, P76414, appearing on behalf of Mr. McCullough. He's been advised of his rights. Will stand mute. We ask the court to enter a plea of not guilty on his behalf.
Thank you. I'm going to enter a plea of not guilty. Court date is December 11, 2024. It is a pre-trial in front of Judge Bryant. Mr. McCullough, bond conditions. You are not to go to the Riopelle address, and you're not to have any contact with the Cassandra Grimes. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Understand that, sir?
Yes, ma'am. Yes, Your Honor.
Okay, Council Vincent, go ahead, Esteban. What's your recommendation?
Thank you, Magistrate. Good afternoon. We're not going to be objecting to a personal because it was charged as a misdemeanor. However, we are going to be asking for a tether and a curfew. Scary incident in the regard that the defendant was found in his ex-girlfriend's house in 2 different instances within a 10-minute period. Apparently, he's already been banned from her employment because he was harassing her up there. And now we have the defendant, just very recently, only in the last couple of days, found in her place of residence while she was sleeping on 2 different occasions. One of which, when she found him in the house, ordered him out for him only to come back into the house. There's a level of danger here, Judge. In order for it not to escalate, we're going to be asking you for monitorization just to make sure that this defendant doesn't approach this complainant, her residence, or anywhere else she is for that matter.
Question, whereas he went to her house, was there any assaultive behavior?
If there was, I would have been asking for a very, very high cash bond.
Okay. Does he have any priors of assaultive behavior?
I didn't find any, Judge.
Okay, thank you.
Your Honor, no objection to personal bond. However, I'm going to ask that you not impose a tether. Mr. McCullough, you understand you can't go to that location or have any contact with her, right?
Yes.
Okay. That being said, Your Honor, my client indicates he's a lifetime resident of the state of Michigan. He tells us he does not have any prior criminal convictions. He's not able to post any money for bond. Your Honor, he's receiving government assistance and also seeking employment. I would just ask, Your Honor, being that this is a misdemeanor allegation of entering without owner's permission, and my client's representation to the court just now, that you consider personal bond with a no contact order of the complainant and the address, but without a GPS tether.
Also, Mr. McCullough, you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes, Your Honor.
The court has heard the representations of both sides this particular matter. There is nothing to indicate that Mr. McCullough has assaultive behavior in the past. In this particular matter, supposedly, he went in at least one time that I see that he needed to talk to the complainant. Supposedly said, trying to explain that they need to talk. There was no damage to the complainant's property. She was not physically assaulted. Mr. McCullough, you may have a personal protection order in the future. That is a court order. Any violation, then you can be arrested on that. But I'm telling you on this right now, any violations, next time it's going to be a monetary bond. But today I'm going to give you a chance, $25,000 personal bond. No contact means no contact. You understand that, sir?
Yes, Your Honor.
All right, that concludes your arraignment. You step aside. What's your name, sir?
Hey, my name is Benny Powell.
Is it Benny Edward Howe Jr.?
Yeah.
Sir, I'm Magistrate Chatfield. Not only do you have a criminal matter, but you also have misdemeanor matters where you did not show up for court. Court is gonna set aside the warrants, recall them. You're gonna get a personal bond. Nobody has to pay any money for you to get out of jail. Maximum penalty is up to 93 days jail and or $500 fine. Gonna enter plea of not guilty. The ticket is P1439929. Drama license suspended, no insurance misdemeanor. Court date is January 8, 2025. Pre-trial in front of Judge Millhouse. Mr. Hogue, is it Hogue?
No, it's
Hi, sir, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights?
Yes.
Okay, criminal matter, it is 240607591. You have an attorney, go ahead, counsel.
Amber Roberts, appearing on behalf of Mr. Howell, has been advised of his rights, will stay on mute. We ask the court to enter plea of not guilty on his behalf.
I'm gonna enter a plea of not guilty. Court dates are December 4, 2024, probable cause conference, followed by preliminary examination, December 11, 2024. Both matters are in front of Judge Robbins. Sir, while this case is pending, you're not to possess any firearms or any other dangerous weapons. Do you understand that? Do
Yes.
you understand that? Thank you. All right, Councilor Ragland, your recommendation.
Yeah, the young man has no prior records at all. He was very cooperative. I'm asking for a $5,000 personal bond and giving a piece of advice. I hope he hasn't come back for any more problems in his future.
Okay.
No
All right,
objection,
sir.
Your Honor.
Thank you, ma'am. Sir, you're gonna get a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Understand that?
Okay, yes.
Okay, go to court, take care of your matter. You can step aside.
Okay.
No, Ms. Roberts.
Hi, good afternoon.
What's your name, sir?
James Davis.
James Franklin Davis?
Yes.
Mr. Davis, this is Magistrate Chartea. You're here in a criminal matter, case number 24060-76101, sir. You have an attorney. Go ahead, counsel.
Amber Roberts appearing on behalf of Mr. Davis, who's been advised of his rights, will stand mute. We ask the court under plea of not guilty on his behalf.
Thank you. I'm gonna enter plea of not guilty. Court dates are December 6, 2024, probable cause conference, followed by preliminary examination, December 13, 2024. Both matters are in front of Judge Taylor. Mr. Davis, while this case is pending, you're not to possess any illegal controlled substances. Do you understand that?
Yes, yes, Your Honor.
Thank you. Counsel Douglas, your recommendation?
Your Honor, Mr. Davis, the people wouldn't object to a 50,000 personal bond. The have noticed for some reason only has some of Mr. Davis's priors. He does from 2014 had a case where he had possession of analogs, possession of a Schedule 1 and 4 substance, and the possession of 25 to 49 grams of a narcotic. He also had a 2019 conviction for operating a chop shop. So, Your Honor, there is an extensive history here. Those are the convictions that aren't showing up in his have notice. He just got off of parole in May of this year. So we do find it concerning that he had the alleged amount of heroin. He is looking at a significant or possibly a significant amount of time, given that he does have that history. And this is a felony, which, Your Honor, is non-assaultive. So I'm not going to object to a personal. I'm asking for a higher of 50,000 personal.
No objection, Your Honor.
Thank you. Mr. Davis, you're gonna get a $50,000 personal bond. Nobody has to pay any money for you to get out of jail. Let's go to court, obey your bond conditions, handle your matter. Thank you, sir. You can step aside.
Thank you.
Yes, sir. Sir, what's your name?
Demetrius Settle.
Mr. Settles. Sir, this is Magistrate Chartea. You're here on a criminal matter, case number 24060-75201, sir. You have an attorney. Go ahead, counsel.
Amber Roberts appearing on behalf of Mr. Settles, who's been advised of his rights, will stay on mute. We ask the court to enter a plea of not guilty on his behalf.
Thank you. I'm gonna enter a plea of not guilty. Court dates are December 6, 2024, probable cause conference, followed by preliminary examination, December 12, 2024. Both matters are in front of Judge Jefferson. Mr. Settles, you have some bond conditions. One is you're not to have contact with the complainant, Corrine Shivers. That means no person-to-person contacts or no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons, and you're not to go back to the Drexel residence in the city of Detroit. You understand those bond conditions, sir?
Yes.
Okay. All right, Counsel Vincent, go ahead, Esteban, please. Your recommendation?
Magistrate, being charged as an FA, we're not going to be objecting to a personal bond because I don't have history here, but we are going to be asking for a tether house arrest. Complainant in this matter is the defendant's 83-year-old mother. And apparently for no reason whatsoever, this defendant starts yelling at his mother, calling her a bitch, and then he ends up pointing a gun at her. She was just trying to get away from this defendant. She was scared of this defendant. And then apparently this defendant is living with his mom. This defendant is 62. His mom is 83. So respectfully, Judge, I don't know what's going on with this defendant, but clearly he's displaying unstable behavior. We feel as though he's a danger and respectfully asking for that tether and home arrest.
Your Honor, no objection to personal bond. However, I would ask that you not impose tether. My client does require medication, of which he indicates he's not receiving while being in custody. He indicates he does have a heart condition. We are going to ask the court to mark his file medical because he needs medication as soon as possible. He's not able to post any money for bond. He's receiving government assistance. He indicates he's a lifetime resident of the state of Michigan. He knows he'll have to stay somewhere else. Without getting too far into the allegations, I can say that my client's maintaining that no gun was pointed at anyone in this matter. I would just note, if you do have the investigator's report in front of you, the reporting party stated she did not observe the defendant point the handgun at the victim. So we would just ask that you consider giving Mr. Settles a personal bond based upon everything presented here today.
Thank you. Court's heard the representations of both sides. He is going to get a $25,000 personal bond. The question is whether or not he's going to be placed on a GPS tether. Courts review the allegations in the investigator's report. Court does find that Mr. Settles is a danger for his protection, but also protection of the complainant. What we are going to do is we're going to place him on a GPS tether with a house arrest. DDC, can you mark Mr. Settles' file medical? DDC?
Yes.
Can you mark Mr. Files medical? I'm sorry, DDC, I didn't hear you.
Yes.
Okay, you're gonna mark his file medical. Thank you, ma'am. Thank you. Mr. Settles, you can step aside, sir. Sir, what's your name? Say that again? Counsel Roberts, I'm sorry, I didn't hear the way your client, what was his last name?
Couldn't hear it either. It's so muffled.
I know. I think Edgerson is your first name, Quan?
Yes.
Thank you. Quan Edward Edgerson, sir. This is Magistrate Echarte. You're here on a criminal matter, case number 2406075-101, sir. You have an attorney. Go ahead, counsel.
Good afternoon, Your Honor. Angela Roberts, appearing on behalf of Mr. Edgerson, has been advised of his rights. Will stay on mute. We ask the court to enter a plea of not guilty on his behalf.
Thank you. I'm going to enter a plea of not guilty. Court dates are December 6, 2024. Probable cause conference followed by preliminary examination, December 12, 2024. Both matters are in front of Judge Giles. Mr. Edgerson, while this case is pending, you're not to have any contact with Kevin Thomas. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. Also, sir, you're not to go back to the Maxwell residence of 8405. You understand that, sir? Do you understand that, sir?
Yes, but I'm not at 8405, 8409.
I understand that. You're not to go near it. My understanding, it looks like that you are next door neighbors.
Yes.
So, again, not to go back to, go in front, go anywhere side of the property, make any Google eyes or anything else. Any type of contact with Mr. Thomas. You understand all those bond conditions, sir?
Yes, I have 3 phones there. Can I send my family there to get them?
Pardon me?
I have 3 phones there.
Your Honor, I think Mr. Ederson's not understanding if he can go back to his residence,
Okay,
which is a different address. It's what, is listed in the investigator's report, but near. I believe they're neighbors next door.
there is an issue of whether or not Mr. Anderson resides at 8409 Maxwell, because supposedly that it is a place that he's squatting. And that there is a notice for that place to be for demolition.
There's no way to tell.
Well, if he's provided that he can stay with a friend if he can't go back to that address according to the court, Your Honor. I think he's just not understanding right now, so if we can just make that clear.
I do understand.
Okay, you'll make that clear, counsel?
So you're saying he can't go anywhere near it, so are you saying he also can't go to 8409?
That is correct.
Okay, all right. Can we at least ask for, well, I know you haven't set bond yet, but he is indicating he's got property there, so can we have a police officer escort, Your Honor?
Yes.
Thank you.
You can have a police escort, one-time opportunity to go to that location and get any type of personal belongings.
Thank you very much.
Council Ragnan, go ahead. Give me your recommendation, sir.
Very assaultive matter, Your Honor. People are asking for $25,000 cash surety bond. This situation occurred, Your Honor, just 2 days ago when the defendant allegedly went over to the complaining witness's home, who was raking the leaves in his front yard. He did see out of the corner of his eye the defendant coming at him with a 4-inch folding knife. He attacked the complaining witness. They ended up on the ground. The complaining witness was holding him until he felt he had stopped trying to be aggressive. He let him up. And with that, he attacked him another time. So we had to take him down to the ground again, Your Honor. And then subsequently, he was let go, went back to a place where he was squatting, where he doesn't live. He was squatting. And the complaining witness had called the police and arrested him. Now, Your Honor, he does have a pending matter that back from 1/9/24, it's home invasion second, malicious destruction of a building causing $20,000 of damage or more, assault with a dangerous weapon. Anyhow,
Okay, what's the bond?
The bond initially in 1/9/24 was $75,000, 10% with a tether. But it's subsequently, I believe it's been reduced because he was out and he came over to this house.
Reduced to what?
I don't have that information, Your Honor. Maybe Mr. Roberts.
I believe that's my son you have mixed up.
Mr. Ederson, I'm gonna just ask, don't just start speaking out. We want to make sure the record's clear. And when Attorney Ragnan's giving some information, we don't want to interrupt him. We'll have an opportunity to respond. And if you still have questions, you certainly can ask them, okay? But everything that you're saying right now is not only being recorded, I also believe it's being streamed. So we want to just make sure that we don't volunteer any information at this time, being that everything's subjected to monitoring and recording at this time. But if we can wait until we have the magistrate's ruling, and then if you still have questions, certainly come back to it, okay?
My question is, Your Honor, I'm not sure that under this birth date, it wasn't available under Odyssey. So I did not see it under Odyssey. It was on. So that's all the information you have. But all I know is this is a very assaultive matter. The complaining witnesses said they have fought a number of times, or he's come over to him, where they have fought, that he causes problems, not only all night long, and problems with other neighbors as well. So we feel he's an extreme danger to this, especially to this witness, Your Honor, trying to stab him twice. And so I think the cash bond is appropriate. Thank you.
Thank you. Council Roberts, go ahead, please.
Your Honor, I need just one moment to pull up what Attorney Reagan was referencing because I'm seeing that it was bound over, so I need a moment to look into what happened at the circuit court. But I will offer to the court in the meantime that my client is a father of 3. It's my understanding that he's 53 years old. He's not able to post any money for bond at this time. He's not currently working, Your Honor. Obviously, he has a position in this incident as well. First of all, he's maintaining that there was never any knife. Also, it's on my understanding that the complaining witness was in my client's driveway and my client had to ask the complainant to leave. But that all being said, this is just the arraignment stage. So we've asked that a not guilty plea be entered on his behalf. I would like an opportunity, if the court is gonna consider that other case, to give me an opportunity to look into that so I can tell the court the bond.
Go ahead, counsel.
Thank you.
Yeah, while counsel is looking, I just would like to mention, if I may, he is a have 4, and he's 2. These are cases from 89, 89,
Yeah.
90, and 98.
Counsel Ragland, I can see that.
All right.
Counsel, I want recommendations and things that are not in the file. So. Cases from 1990, 1989, 98, even 98, over 20 years. So if you have anything recent, other than what Counsel Roberts is checking on, whether that case belongs to him or not,
Have that case number.
and what,
Need it.
So, is the incident date 1/6/2024?
It probably is, because he was arraigned on 1/9/20.
Okay, so Your Honor, what I see on that, and that's with home invasion, home invasion second, NDOB 20,000 or more, FA and malicious destruction of property 200 to 1,000, is that on 1/12/24 it was a 75,000, 10% with a tether. And then I'm trying to see, it looks like bond was continued. As I'm looking, I don't see that a different bond amount.
I went to the registered cases and looked in there as well, and it just showed it bound over.
Yes, I don't dispute that it's bound over. It's scheduled for, it looks like there was a finding of incompetent on August 5th, 2024, and then a commitment review hearing on 1/13/2025.
Okay. That,
so what was there any bond?
The last bond that I see was 75,000, 10% with a tether, and then I see reference to that being continued, but I don't then see another bond amount as I'm scanning now.
Okay, all right. Can you do me a favor? Can you look at the date of birth?
I don't know. I don't know if they. I don't think I have access to that on here on the internet, Your Honor. I don't see a date of birth.
Okay.
the
You know who the complainant is in that case?
They have at least according to what I can see there may be multiple that I don't see, but I only see one, which is Angelo Edgerson.
Okay. And does it say the location of the offense?
I'm sorry, just to help out with this whole thing, Steve Vincent for the people. I just went to the Register of Actions for 3060. The offense date for 1/6/2024 has a birth date of 1987, if that helps.
Okay, so wrong person then.
Yep.
Thank you.
Mr. Vincent. Appreciate it.
Okay, all right, Counsel Roberts. Anything else, Council Roberts?
Your Honor, I'm just asking for a personal bond.
Thank you. Court heard the representations of both sides, this particular matter. Reference to Mr. Eggerson. This court does believe that Mr. Eggerson is a danger in this particular matter, but we're gonna give Mr. Eggerson a chance. But in order to protect the complainant in this matter, he's gonna be placed on a GPS tether house arrest. And his bond is gonna be $50,000 personal bond. That concludes Mr. Eggerson's arraignment.
Thank you. Sorry about that, Your Honor.
That's all right.
Ms. Roberts, too.
Thank you, Your Honor.
Thank you. What's your name, sir?
Curtis Dodd.
Mr. Dodd. Curtis Lamont Dodd.
Yes, ma'am.
Sir, this magistrate at Chartea, sir, you're here on a criminal matter. Case number 2406076-301, sir. You have an attorney. Go ahead, counsel.
Amber Roberts, appearing on behalf of Mr. Dodd, who's been advised of his rights, will stand mute. We ask the court to enter.
Plea of not guilty. Court dates are December 4th, 2024. Probable cause conference, followed by preliminary examination, December 11th. Mr. Dodd, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes, ma'am.
With your recommendation,
Jennifer Douglas for the people, P 72748. Your Honor, no objection to 5,000 personal. Mr. Dodd does not have any pending case on probation or parole. His lien is not showing that he's ever had any contacts with police. No objection to 5,000 personal.
No objection,
Thank
Your
you.
Honor.
Mr. Dodd, you're gonna get a $5,000 personal bond. Nobody has to pay any money for you to get out. Good luck. You can step aside, sir.
Thank you.
What's your name, sir? Sorry, say that again. Thank you. Mr. Donald, I'm magistrate at Chartea. You hear criminal matter, case number 2406076-401, sir. You do have an attorney. Go ahead, counsel.
Amber Roberts, appearing on behalf of Mr. Donald, who's been advised of his rights, will stand mute. Ask the court to enter a plea of not guilty on his behalf.
Thank you. I'm gonna enter plea of not guilty. Court dates are December 6, 2024, probable cause conference, followed by preliminary examination, December 13, 2024. Both matters are in front of Judge Jefferson. Mr. Donald, you're not to possess any firearms or any other dangerous weapons. You're not to have contact with Alicia Jones or Phyllis Jones. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Further, sir, you're not to go back to 3336 Taylor, City of Detroit. Do you understand that?
Yes, Your Honor.
Council Vincent, go ahead, Esteban, please, your recommendation.
Thank you, Magistrate. Steve Benson, P 71917, being charged with 2 FAs, 2 FFs. We're not gonna be objecting to a personal. We are gonna be asking for monitorization as well as a curfew. This defendant has a prior April 19th of 22 conviction. He ended up pleading to a reduced misdemeanor. Apparently it was a weapons firearm possession of a loaded firearm in a motor vehicle. He got 1 year probation on that. And now we have allegations regarding an individual that ended up pulling a gun out on 2 different people, allegedly because his girlfriend had a beef with the neighbor about some kind of flower pot. And then the police end up finding the firearm on this defendant's person. He knows he shouldn't have a firearm. He's possessing the firearm and he's being accused of pointing that firearm at 2 different people. We find a level of danger here. Respectfully, we're asking for that tether with the curfew.
Your Honor, no objection to a personal bond. However, I would ask that you not impose a tether. Mr. Donald's maintaining that no gun was ever pointed at anyone. It's my understanding that he can stay with his mother while this matter is pending. He indicates being a lifetime resident of the state of Michigan and a father of 1, not able to post any money for bond at this time. It's my understanding that he is currently working, Your Honor. He works Monday through Friday, 9 a.m. to 5:30 p.m. and has attended some college. I would just ask that you consider not making him have to remain in custody for a tether if possible.
So, Counsel Roberts,
Yes.
so, he has a prior conviction from when?
If you don't know it, I have it. It's April 19th of 22. It was for a misdemeanor weapons possession in a motor vehicle, Judge.
And is that,
Courts heard the allegations. Courts read courts heard the arguments, read the allegations in the investigator's report. Allegedly, it was Mr. Donald. He did point a gun at the complainant. Firearm was found. He's gonna get a $50,000 personal bond, but seeing as that these are allegedly residents or neighbors, looks like across from each other, same side, on the same street, but on opposite sides. This court is gonna put a GPS tether work only.
Your Honor, he does say he can stay with his mother, and it's my understanding that's in Ferndale. Is that correct, Mr. Donald?
Yes, ma'am.
If that be the case, Your Honor, if the court orders no contact, does he have to still have the tether as long as he goes to his mom's house?
For the protect both. Whether he goes to Ferndale or not, still a GPS tether. $50,000 personal bond.
Thank
You didn't say house arrest, though, did you?
No, work only.
Work only, okay.
Because Counselor, I do believe you said that he's working,
Yes,
so I'm gonna
thank
put
you.
him GPS tether work only.
Thank you, Your Honor.
Thank you. Mr. Donald, that concludes your arraignment, sir. You can step aside. Yes, the gentleman that's waving his hand. What's your name, sir?
Everett Stewart.
I'm sorry, say your name again, sir?
Everett Stewart.
Mr. Stewart, I have you listed as Everett Bernard. So, Everett Bernard Stewart?
Yes, ma'am. That's me.
Okay, yes, that is you. Thank you. Mr. Stewart, this is Magistrate Echavarria. Not only do you have a criminal matter, but you also have some misdemeanor matters that you did not show up for court. Court is going to recall the warrant on the misdemeanor matters. Maximum penalty is up to 93 days jail and or $500 fine. You're getting a personal bond. Nobody has to pay any money for you to get out of jail. Entry plea of not guilty. The tickets are P1067768. Drama license suspended, no insurance misdemeanor. Last ticket is P1388986. Drama license suspended. Court date is January 9, 2024. Pre-trial in front of Judge Archer. Mr. Stewart, you have a right to remain silent. Anything you say, orally or writing, it can be used against the court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, sir?
Yes, ma'am.
Okay, your criminal matter, case number 240-6063201. Sir, you have an attorney. Go ahead, counsel.
Gilbert Roberts appearing on behalf of Mr. Stewart. Your Honor, he's been advised of his rights. Will stay on mute, and we ask the court to enter a plea of not guilty on his behalf.
On enter plea of not guilty, court dates are December 4, 2024, probable cause conference, followed by preliminary examination, December 11, 2024. Both matters are in front of Judge Robbins. Mr. Stewart, bond condition, you're not to possess any firearms or any other dangerous weapons. You understand that?
Yes, ma'am.
Thank you. Council Douglas, go ahead, Esteban. Recommendation, please.
Jennifer Douglas for the people, P 72748. Your Honor, no objection to 5,000 personal. This dates back to September 22. It's non-assaultive, not aware of any criminal history. No objection to 5,000 personal.
No objection, Your Honor.
Thank you. Mr. Stewart, you're gonna get a $5,000 personal bond. Nobody has paid money for you to get out of jail. Good luck. You can step aside, sir. What's your name, sir?
Keith Jones, Your Honor.
Keith Lamont Jones?
Yes, ma'am.
Mr. Jones, this is Magistrate Chuck there. Case number 240-607-6601, sir. You have an attorney. Go ahead, counsel.
Jennifer Roberts, appearing on behalf of Mr. Jones, who's been advised of his rights, will stand mute. We ask the court to enter plea of not guilty on his behalf.
Thank you. I'm gonna enter plea of not guilty. Court dates are December 6, 2024, probable cause conference, followed by preliminary examination, December 13, 2024. Both matters are in front of Judge Jefferson. Mr. Jones, while this case is pending, you are not to go back to the location, 76 Henry Street, which I believe is Little Caesar's Team Store. Do you understand that
Yes,
bond
sir.
condition, sir?
Yes, Your Honor.
Thank you. Council Douglas, go ahead, Esteban, please.
Your Honor, Mr. Jones, the people are asking for a bond of 50,000 personal, but also asking for tether and a curfew that allows for work only. The reason we're asking for that is according to Otis, Mr. Jones is on both probation and parole. I know the investigator's report refers.
Hold on, Mr. Jones. I'm sorry.
The investigator's report refers to him being on probation. I did check Odyssey, and Odyssey was showing violations of probation warrants that were entered in September of this year. I did not see entries after that. Your Honor, Otis is showing a 2019 conviction for retail fraud, which is listed in the HAB notice. There are other convictions listed in the HAB notice. There are a number of convictions not listed in the HAB notice that do appear on Otis, which involve a number of retail fraud first cases. Your Honor, any recent cases are non-assaultive on Mr. Jones's behalf, so that's why we don't have an objection to a personal bond, Your Honor. But given that he does have multiple retail fraud cases, we are asking for that tether with a curfew that allows for work only, seeing as how he is currently under supervision on more than one case, but allegedly is engaged in theft again. So, Your Honor, we think a tether would address any sort of safety concerns. But given this non-assaultive, no objection to personal.
Council Douglas,
Yes, Your Honor.
you mentioned parole. Is he on parole or is there a parole detainer?
Your Honor, according to Otis, he's on parole. It looked like Mr. Jones is saying that's not correct. Otis is
I
showing.
completed parole March of 2023, last year. I'm on parole. I completed that in Howard, Michigan. That's what I was born to.
Mr. Jones, you don't need to say anything. Can you get me the officer over at DDC? Okay. Officer, can you tell me in reference to Mr. Jones, is there a parole detainer?
Yeah, he's currently on probation.
Is there a
No
parole
parole.
detainer?
No
Okay,
parole.
thank you. Thank you. Go
So
ahead,
then-
Council Council Roberts, go ahead.
I would ask for a personal bond, Your Honor. Obviously, if there's some warrants, then, he's gonna have to take care of those. But my client indicates that he's 53 years old. He's provided us with an address in the city of Detroit. He indicates being a lifetime resident of the city of Detroit, indicates that he currently lives with his girlfriend. It's my understanding he is currently working. He works Monday through Friday, 9 a.m. to 5 p.m. He's not able to post any money for bond at this time. He does have a medical condition, Your Honor, so if the court's not inclined to release him today, I would be asking that the court make sure his file is marked medical. It's my understanding he does have a GED. And this particular offense, Your Honor, although there's priors and although this is the second offense, the offense here, or second or subsequent offense, I should say, it's still retail fraud, which is a non-assaultive crime, Your Honor. So we're just asking that you consider personal bond for him.
Well, I believe the recommendation was personal bond. He's gonna get a $50,000 personal bond. The question is whether for him to get a tether with a curfew. The court has heard information that there is no parole detainer. He is on probation. Whether or not he's gonna be violated, I'll let the trial court on that matter deal with it. In this matter, it is non-assaultive. Nothing to indicate in the investigator's report that there was any type of assaultive contact, assaultive behavior. So we're gonna go with the $50,000 personal bond, and we're not gonna put a tether on him. However, Mr. Jones, just so you understand, even though that I may give you a personal bond, there's other cases in which you have to pay, or somebody has to pay a monetary bond. The court doesn't have control over that. You understand that?
Yes, Your Honor.
Okay, all right, that concludes your arraignment. You can step aside.
Your Honor, you said with a tether?
I said no tether.
Okay, great, thank you.
What's your name, sir?
Keenan Andrews.
Keenan Dwayne Andrews, is that correct?
Yes, ma'am.
Sir, this is Magistrate Chartea, sir. Not only do you have a criminal matter, but you also have misdemeanor matters where you did not show up for court. We're gonna recall the warrants. You're gonna get a personal bond. Nobody has to pay any money for you to get out of jail on the misdemeanor matters. Maximum penalty is up to 93 days jail and or $500 fine. First case is, I'm gonna enter a plea of not guilty. First case is P1001392, driving while license not valid or improper license. Next ticket is P1200350, count 3 only, driving while license suspended. Next ticket is P1321035, driving while license suspended, no insurance misdemeanors, improper plates. Next ticket is P1348178, driving while license suspended. Last ticket is U645044122, violation of City Controlled Substance Code. Court date is January 8th, 2025. Pre-trial at 1:30 in courtroom 533. Mr. Andrews, you have a right to remain silent. Anything you say orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you for expense. Understand those rights, sir?
Yes, ma'am.
Okay, criminal matter, case number 240603691. You have an attorney. Go ahead, counsel.
Amber Roberts appearing on behalf of Mr. Andrews, who's been advised of his rights, will stay on mute. We ask the court to enter a plea of not guilty on his behalf.
When enter a plea of not guilty, court dates are December 4, 2024, probable cause conference, followed by preliminary examination, December 11, 2024. Both matters, let's see, are in front of Judge Robbins. Okay. All right, Mr. Andrews, bond conditions, you're not to possess any firearms or any other dangerous weapons, and you're not to drive without a valid driver's license. Understand those bond conditions, Mr. Andrews?
Yes, ma'am.
Okay. Counsel Vincent, your recommendation, please.
Thank you, Magistrate. Steve Vincent, P71917. Here, we're going to be recommending personal.
No objection.
Thank you. All right. Mr. Andrews' recommendation is $15,000, personal bond. That's what it's going to be. The charges are non-assaultive, and it is from more than a year ago. $15,000 personal bond. Nobody has paying money for you to get out of jail. Good luck, Mr. Andrews. You can step aside.
Your Honor, can I his dates again, please?
Ms. Lisa, can you give him the dates?
Thank
Mr.
you.
Andrews.
What was the first one?
December 4th.
Thank you very much.
BDC, I'll see you on the female side.
Yes, ma'am.
Thank you, ma'am.
Magistrate, did I miss something, that Mr. Dawson was he like a Zoom or something then?
Didn't zoom in. Neither
Oh.
did, Craig Johnson did not come in either.
Okay, I appreciate you. Thank you.
No problem. I thought maybe they would come in a little bit later, but no. Dawson and Johnson, no shows.
You gotta get this going. Ms. Campbell. Have a seat right there in the chair, state your full name for the judge.
What's your name, ma'am?
Kelly Nicole Kemp.
Nicole Kim, thank you. Ms. Kim, this is Magistrate Thad. Not only do you have a criminal matter, but you also have misdemeanor matter where you did not show up for court. Court's gonna recall the warrant. You're gonna get a personal bond. Nobody has to pay money for you to get out of jail. Maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. Court is gonna enter a plea of not guilty. Case number is P1131154. Improper place, driving under a title vehicle, no insurance misdemeanor. Court date is January 8, 2024, January 8, 2025, pre-trial in front of Judge Kennedy. Ms. Kemp, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Rights to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, ma'am?
Yes.
Thank you. Criminal matter, case number is 240-607-6001, ma'am. Please say your full name.
Kelly Nicole Kemp.
Thank you. You have an attorney, go ahead, counsel.
Good afternoon, Ianca Roberts, appearing on behalf of Ms. Kim. She's been advised the rights will stand mute after court enter a plea of not guilty on her behalf.
Thank you. Court is going to enter a plea of not guilty. Court dates are December 6, 2024. It is a probable cause conference followed by preliminary examination, December 12, 2024. Both matters are in front of Judge Jefferson. Okay. Ms. Kemp, while this case is pending, there's no assaultive or combative behavior on your part. Do you understand that bond condition, ma'am?
Yes.
Let's see, also, you are not to go back to the location of the Edward residence. You understand that, ma'am?
Yes, Your Honor.
Bring this on your paperwork. Also, ma'am, you're not to have contact with, looks like Lenora Hyman. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Do you understand that, ma'am?
Yes.
Council Douglas, go ahead, Mr. Bond, please.
Your Honor, on Ms. Kemp, the people asking for a bond of 25,000 personal with a teller to ensure no contact. Here we have concerns for the safety of the complaining witness, given that Ms. Kim's accused of being in the state to the point where she broke a window, with officers indicating they did in fact see a broken window with glass, and that after Ms. Kim appeared to have calmed down after being taken to the hospital, she allegedly then became upset again about getting cuffs and swinging at one of the officers, to the point that one officer needed assistance from hospital security to be able to get cuffs back on her. So we do have concerns for safety of this complaining witness and Ms. Kim going back to that location. So we are asking for a tether, not gonna object to a 25,000 personal if there's a tether.
Council Roberts, go ahead, ma'am.
Your Honor, no objection to personal bond. However, I would ask that you consider not imposing a tether. It's my understanding that my client does have asthma. At this time, she's not able to post any money for bond. She is a lifetime resident of the state of Michigan. She's a mother of one. She lives with her son. It's my understanding, according to my client, at this time. Oh, she is receiving government assistance, Your Honor. She's not currently working. And so I would ask that you consider not having her potentially remain in custody awaiting a tether, and consider a no contact order. For Your Honor.
All right. Ms. Kim, you're gonna get a $25,000 personal bond. The issue is whether or not you're gonna get a GPS tether. Court heard the representations, both sides. Court looked at the allegations in the investigator's report. Okay. Court does find, using clear and convincing evidence, that she is a danger, because not only to Simon, but also it looks like that she became hostile with police. Supposedly, allegedly said that she spit on an officer and then allegedly swung at an officer. So while we are gonna give her a personal bond, she's gonna be placed on a GPS tether, house arrest. That concludes Ms. Kim's arraignment.
Thank you, Your Honor.
Your Honor.
Here we go. This one's first. What's your name, ma'am?
Desire Jones.
Ms. Jones, this is Magistrate Chuck Babb. You're here on a criminal matter, case number 240607641. Ma'am, you have an attorney. Go ahead, counsel.
Gabrielle Roberts appearing on behalf of Ms. Jones, who's been advised of her rights, will stand mute. We ask the court to enter a plea of not guilty on her behalf.
Thank you. I'm gonna enter a plea of not guilty. Court dates are December 6, 2024, probable cause conference, followed by preliminary examination, December 12, 2024. Those matters are in front of Judge Giles. Ms. Jones, some bond conditions. One, you're not to have contact with Dizona.
Understood.
Robertson. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. Also, you're not to go back to the Lake Point residence in Detroit. You understand those bond conditions, ma'am?
I sure do, ma'am. I understand completely.
Good. Counsel Ragman, give me your recommendation, please.
Yeah, it's a very salty matter. The defendant allegedly was swearing at her 1-year-old baby, and the complaining witness heard her, went into the room, and told her she shouldn't swear at her little baby like that. With that, the defendant got upset and started assaulting by punching her and hitting the complaining witness. The complaining witness then went in the kitchen, so the defendant followed her and grabbed the knife, and then the complaining witness was putting her arm out to keep her away from her, and she kept slapping her away, trying to stab her with the knife. So Your Honor, the complaining witness wants to press charges. I think it's very assaultive. The interesting, Your Honor, is that in the month of August 12th, 1984, she was charged with 4 felonies, assault, great bodily harm, less than murder. And that complaining witness dismissed the charges on the 28th of August. On August 30th, she's charged again with assault with a dangerous weapon and so on. And that same complaining witness, excuse me, the same
Ms. Jones,
complaining
don't
witness.
say anything. Go ahead. I'm sorry, counsel.
I'm just going to say the same complaining witness then, gentleman, dismissed those charges against her as well. So it seems like she's got an assaultive past, and I'm concerned about the welfare of the complaining witness here. So we're going to ask for a $5,000 10% bond, plus we're going to ask for a tether home arrest, not at that location. Thank you, Your Honor.
Okay, I'm sorry. Give me your recommendation again.
$5,000, 10% cash, tether home arrest. Thank you.
Go ahead, Counsel Roberts.
Your Honor, respectfully ask for a personal bond. It's my understanding the complaining witness in this matter is my client's sister, and she indicated she does not reside with the complaining witness. It's my understanding my client is currently in school online. She also is a mother and has full custody of her child. It indicates that she's the sole provider of her child. She also says that she's a lifetime resident of the state of Michigan, and she indicates to our office that she does not have any prior criminal convictions. She is currently working, Your Honor. She also does get some government assistance, but she's not able to post any money for bond. I would respectfully ask that you consider a personal bond as long as she doesn't have any contact with her sister and not make her have to remain in custody awaiting a GPS tether. Well, Ms. Jones, you understand you can't have any contact with your sister, right?
I completely understand. I will not have any contact with her. I do have somewhere else to go. I plan on getting out of here to take care of my daughter and going to work.
Very
That's
good.
it.
Thank you, Ms. Jones. So we would just ask that you take her at her word, Your Honor.
So counsel, does she work or no?
Yes.
I'm sorry, I didn't hear you.
Yes, she does, Your Honor. She does delivery for Amazon.
Okay. Well, court's heard the representations of both sides. Court's also read the allegations of this particular matter. Allegedly, Ms. Jones, there seems to be, she has some sort of criminal history. There's been at least 2 cases. They are dismissed. They are the same complainant. Is that correct, Counsel Ragland?
Wasn't the same complainant at that time, Mr. Thurman. This case is different. Her sister.
Okay, I'm sorry. So there's at least 2 ended up being dismissed, a different complainant in this particular matter. However, what's reading in that allegedly Ms. Jones makes a statement to, I guess, I'm not sure if it was to the complainant or not, saying, I will pay you back for your laptop. Tell them you're not pressing charges. So what I am going to do, this court does find that Ms. Jones is a danger, but I'm going to give her a $50,000 personal bond. But I'm going to place her on a GPS tether, work only.
Your Honor, can I have her PCC date again, please?
I'm sorry, say that again?
Can I have her PCC date again, please?
Sure. December 6th and December 12th.
Thank you, Your Honor.
Thank you. That concludes Ms. Jones's arraignment.
Come on now, Michelle.
Thank you.
Thank you, Your Honor.
Thank you.
Hey, y'all want anybody up there use the phone right now?
It's Jones though.
Hello,
What's your name, ma'am?
Dorita Franklin.
Doretha Marie Franklin, ma'am?
Yes, ma'am.
Ma'am, this is Magistrate Chartea. Hold on for a moment. Oh, here it is. Okay. Not only do you have a criminal matter, but you also have, it looks like, a couple misdemeanor matters where you did not show up for court. Court is gonna recall the warrant. You're gonna get a personal bond. Nobody has to pay any money for you to get out of jail. Maximum penalty is up to 93 days jail and a $500 fine. First ticket and only ticket is P 1262886. Count 1, drive while license not valid or improper license. Count 2, no insurance misdemeanor. Again, maximum penalty is up to 93 days jail and a $500 fine. Enter plea of not guilty. Court date is January 4th. Excuse me. Let me repeat that. Court date is January 7th. January 7th, 2025. Pre-trial in front of Judge Williams. Ms. Franklin, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney. Have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, ma'am?
Yes, ma'am.
Okay, criminal matter, case number is 22045016001, ma'am. You have an attorney. Go ahead, counsel.
Amber Roberts appearing on behalf of Ms. Franklin, who's been advised of her rights, will stand mute. We ask the court to enter plea of not guilty on her behalf.
Thank you. I'm gonna enter a plea of not guilty. Court date is December 11th, 2024. Pre-trial in front of Judge Bryant. Ms. Franklin, some bond conditions. You're not to possess any firearms or any other dangerous weapons, and you're not to have contact with Javon Porterfield. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. This is from 2021. Counsel Douglas, go ahead, Esteban, recommendation.
Actually, this is Mr. Vincent's case. He fell off. He should be in the waiting room.
Okay, thank you, ma'am. I see him.
Am I allowed to speak or no? I never.
Hold on, Ms. Franklin. Hold on. We're gonna
Please don't say anything, Ms. Franklin. All right, Counsel Vincent, on Ms. Franklin, what's your recommendation?
Thank you, Magistrate, and thanks for letting me back in. Incident date, April 18th of 21, charged as an A and B. I see the warrant being entered about a year and 2 months later. The curious thing, though, Magistrate, here is if you looked at the allegation, I don't know why they didn't charge it as an FA. It's kind of curious. And when I look at things and they're curious, it kind of sets red flags, not taking away from the significance of this, but because of that, and there's no history, nothing since the warrant was filed between the parties, we're not going to be objective.
You don't object to a personal bond?
No, not at this time, just based on all of the different things going on with this case. No.
Thank you.
Objection, Your Honor.
Thank you. All right, Ms. Franklin, you're getting a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. You understand that, ma'am?
I can't hear you. I gotta pay
And you're
$5,000.
getting a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you
Okay.
understand what I said?
Yeah, my hearing is kind of bad. I'm sorry.
Okay,
Yes.
5,000 personal bond. Nobody has to pay any money for you to get out of jail.
Okay.
Okay, good luck, ma'am.
Thank
you. That concludes the arraignment. Thank you, folks. Have a good night. Have a good holiday tomorrow.
You too. Thank you.
Thank you.
Yeah,
Thank you,
clerk.
DPC.
Happy
Thank you, everybody.
Thanksgiving,
Bye, Your
everyone.
Honor. Have a good
Bye.
weekend.